Tēnā koutou katoa. My name is Juliana Carvalho. I'm the head of advocacy at Blind Low Vision New Zealand. Well, welcome to the Know Your Rights webinar series. This first webinar is brought to you in partnership with the Human Rights Commission. Thank you to Dr. Esther Woodbury, lead advisor to the Disability Rights Commissioner, and Anna Costley, senior practice advisor for the Information and Dispute Resolution. Thank you so much for joining us today. I will now invite my colleague David to do the karakia.
Kia karakia tātou. Whakataka te hau ki te uru. Whakataka te hau ki te tonga. Kia mā kina kina ki uta. Kia mā taratara ki tai. I hai ake ana te atakura. He tio, he huka, he hau hu. Tihei mauri ora. Cease the winds from the west, cease the winds from the south. Let the breeze blow over the land. Let the breeze blow over the ocean. Let the red-tipped dawn come with a sharpened ear, a touch of frost, a promise of a glorious day. Amen.
Thanks, David. So the purpose of this webinar is to explain how the Commission can help with discrimination complaints and when and how you can make a complaint to the Commission and what you can expect when you do make a complaint. So before I start, just a few housekeeping. So the chat function, your video and audio are turned off. And after our guests finish the presentation, we will open the floor for the Q&A. And then you can either type your question in the Q&A or you can raise your hand by clicking the raise hand icon. Then David, our Zoom master, will unmute you and you can make your question verbally. So now, Esther, Anna, the virtual stage is yours.
Thank you so much, Juliana. Thank you to everyone at Blind Low Vision for having us. My name is Esther Woodbury. I'm the lead advisor to the Disability Rights Commissioner and my colleague.
And I'm Anna Costley. As previously said, I'm the senior advisor in the Information and Dispute Resolution team.
Just a quick visual description. I am a Pākehā woman wearing glasses and a purple dress.
And I am also a Pākehā woman wearing a navy top. I am much taller than Esther.
Thank you. So we're going to start our presentation now. We've got a PowerPoint presentation and we'll be just speaking through it, speaking as we go. So can I just get a confirmation that you can see? I think you need to do like a presentation.
Yes.
There you go. There we go.
Everyone. So we are from Kāhui Tika Tangata, the Human Rights Commission, and we're just going to be talking through some of your rights, and then we'll have questions at the end.
Okay. So, the Human Rights Commission has got many, many functions, and we're going to be focusing in this presentation on how we help provide information and how we help with complaints. So keep in mind that what you're hearing today isn't absolutely everything the Commission does. It's just one part of it, but it's a really, really important part of it, and is likely the part that's most relevant to you as well.
So just for a bit of context, I work directly with the Disability Rights Commissioner, and we do our work we call strategic advocacy. So the Disability Rights Commissioner can't get directly involved in individual complaints. The work that we do is we're working with groups around issues that many people experience. So, for example, Blind Low Vision might be an organisation that we work with. Blind Low Vision might say, here are some themes, some general areas that the people we work with are experiencing, And we work around systemic advocacy. So we will work with government, we'll work with community, we'll work with the media to highlight these issues and also to monitor them. But the complaints team, the complaints and dispute resolution team, they work specifically under the Human Rights Act. Whereas the strategic advocacy, quite often we're working around the UN Convention on the Rights of Persons with Disabilities, for example, the Universal Declaration of Human Rights, the Declaration on the Rights of Indigenous People, for example. We work around many of those sort of international conventions and treaties.
So the Human Rights Act gives us some very specific functions, one being to provide information to members of the public about discrimination and to provide dispute resolution for discrimination complaints. So those are our key functions outlined in the Human Rights Act. So obviously a huge focus on discrimination in the Act, and it's got a specific definition in the Human Rights Act that is narrower than what's commonly understood to be discrimination. So discrimination happens everywhere all the time, unfortunately, but the kind of discrimination that is unlawful under the Human Rights Act is a specific kind. So this slide is kind of broadly going to introduce you to that. So there are four main components to what constitutes discrimination under the Human Rights Act. There is, firstly, different treatment compared to other people in a comparable situation. Because of a protected ground under the Act, we're going to come to those in a second. The discrimination has to happen in particular areas of public life, which we'll also come to in a second. And it needs to cause you harm or disadvantage as a result of that different treatment. So they are the four really important things that make up the definition. The Human Rights Act does have some exceptions. So sometimes something that looks like discrimination, there might be an exception in the Human Rights Act that says that it isn't. But we don't want you to focus too much on that, because the key is, if you think discrimination is happening to you, we want you to contact us, and we can chat with you and tell you at that stage about any possible exceptions that may apply. But just to highlight one really briefly now as an example. So the Act makes it unlawful to discriminate against you in the area of housing. But there is an exception in the Act around shared housing. So very briefly, and this is a complete paraphrase, but it's unlawful to discriminate against a landlord to discriminate against a tenant who's renting the whole house, but it's not unlawful for a flatmate to discriminate against another potential flatmate. So the Act lets people choose who they live with in the same house, but it doesn't let you treat someone unfairly and differently if you're renting your whole house out to them and you're not going to live there as well. So that's just one exception. There are a whole bunch of them, but those are the key factors that make up unlawful discrimination under the Human Rights Act. Moving to the next slide. So we've just briefly listed not all, but some of the protected grounds under the Act. So it's unlawful to treat you differently compared to others based on your age, your sex, your disability, your race, colour, ethnicity, or nationality. Often there's kind of some blurry boundaries between those ones, and your sexual orientation. There's also a few more, but those are the most common ones that we've just highlighted here, and we're just keeping it brief in the interest of time. But you can find all this information on our website, or you can contact us to find out more as well. So those are some of the key ones.
So the Human Rights Act talks about disability, and it's very, very broad understanding of disability, which is really great. So it includes having a physical, sensory, psychosocial, learning or neurological disability, but it also specifically mentions people who rely on, for example, assistance, disability assistance. So it's a very broad definition, which is really great. It also includes illness. So yeah, everyone should be covered, and we have a very broad understanding of disability. So that's
okay. Anna speaking again here. So this slide talks about the areas of public life that the Act covers. So like I mentioned earlier, you're not protected from discrimination by this Act absolutely everywhere. It talks about specific areas of public life. Some of those are government services or public services, employment, education, access to goods and services and public facilities, and provision of housing. There's a few more niche ones, but those are the headline acts. Importantly, it doesn't cover things like personal relationships. If members of the public treat you in a certain way out on the street, it doesn't cover those interactions. But again, just want to underscore, if you feel you've been discriminated against and you're not sure if there's an area of public life that applies, please contact us. We will explain that to you. And sometimes there's ways we can help, even if it's not covered by the Act. So we just really, I hope if you take one thing away from today's webinar, it's just contact us and ask, we'll help you. So I've broadly outlined the broad definition of unlawful discrimination, the most kind of common type. When you hear the word discrimination, that's what you think of. But the Human Rights Act talks about other forms of discrimination as well. Racial harassment is one, sexual harassment, victimization, and indirect discrimination. Victimization has a specific meaning that I wouldn't have known about until I took this job, so I'll just explain that briefly. It means if you've made a complaint or made a protected disclosure, which is, a whistleblow, if you've whistleblowed at work or if you have made a complaint and as a result of that you've been treated unfairly, that's what victimization means in this context. So, for example, if you made a discrimination complaint against your employer and then they turned around and tried to dismiss you based on that, then you'd have grounds to come to us with a victimization complaint as well as that original discrimination complaint. And indirect discrimination is something that appears neutral on the surface, but actually has a disproportionate impact on you or a group of people based on one of those protected grounds. So that might be a policy that applies to everyone, but unfairly affects people with a disability, people of a certain age, that kind of thing.
And we talked about what's an example of that, and it might be if a government website has a capture function, a capture security function on their website, which means that you need it to proceed further with accessing government support services. If you have a visual impairment and can't use capture, that's indirect discrimination, because they're using a security function which is actually not accessible to everyone. I'm going to talk a little bit about reasonable accommodation. And in the disability sector, we talk about reasonable accommodation quite often, and it's talked quite substantially in the United Nations Conventions on the Rights of Persons with Disabilities. And it's also essentially contained within the Human Rights Act. And so the Human Rights Commission receives complaints around reasonable accommodation, and that can go through the complaints and dispute resolution services. We've recently updated some guidance on reasonable accommodation. So that's the Human Rights Commission, and we worked with the Ombudsman and the DPO Coalition, because together the Human Rights Commission, the Ombudsman and the DPO Coalition make up the independent monitoring mechanism. So we monitor how the government is progressing against the UN Convention on the Rights of Persons with Disabilities. So we've got guidance, new guidance up on all of our websites around reasonable accommodation. And an example of that is that well, it can be quite nuanced what reasonable accommodation means, and it has to essentially, it's always going to be sort of understood on a case-by-case basis, because there can't be, whether you're talking about an employer or a school, there cannot be an undue burden on the employer or the school or whoever it is you're making a complaint of reasonable accommodation against. But actually, reasonable accommodation means not just that the employer or the school, for example, think it's reasonable, but that the accommodation is reasonably able to accommodate a disabled person in that space. So yeah, it's that the accommodation is reasonable, and essentially that the accommodation is effective. So sometimes when you talk about reasonable accommodation, you're talking about effective accommodation, but there is that element of it not putting an undue burden on an organisation or another individual. So an example of that might be if someone is saying that they could do a job if a lift was installed in a building, it might be an undue burden on an organisation to install a lift into the building that they operate out of. But it is, again, on a case-by-case basis, so that undue burden needs to be kind of understood in a very wide context. So that's reasonable accommodation.
Yes, and again, if you're not sure if you're in a situation that might fit within that, get in touch with us. We can provide more information. And again, it's not, at no point is the Human Rights Commission going to turn around and say, yes, you've been discriminated against. Yes, they should have reasonably accommodated your disability. We'll get to this in a second, but we'll just help you talk to them about it and have a safe process to resolve that complaint. It's just about helping the people involved resolve it between themselves. So, what a perfect segue onto the how we can help slide. So basically, when you contact the Human Rights Commission, the group that I'm in has got two teams. So there's a frontline team who help with all those initial inquiries and complaints, and then there's a dispute resolution team who run the dispute resolution processes for those complaints. So first of all, I'm just going to talk about the first people you'd come into contact with. We have a team of absolutely lovely case advisors who can provide information about a wide range of human rights issues, not just discrimination. We'll provide information about anything we can, human rights related. We can, if we're not the right people to help with something, we can refer you on to other agencies who can help or make other suggestions about what you could do in this situation. We connect lots of people with support, so that might be social service agencies, mental health support, helplines, that kind of thing. Whatever support is required, we'll make suggestions or directly connect people. A big part of our role is referring those complaints of unlawful discrimination through to our dispute resolution team. So we would provide the information in the first instance to help people understand if that's an option they want to take, and when you do, flick those on through to the dispute resolution team. And we can also offer some extra support around harmful speech. So hate speech is much talked about in society, and there's no specific laws that cover it. But if someone has experienced hate speech or harmful speech because of their disability or their race or their gender, that kind of thing, there's ways we can help. So we want to hear about those situations as well. So just I've got a few stories here, anonymized, of course, about how our frontline team can help with situations. So one example is that somebody contacted us because they had been refused access to a form of transport because they had a disability assist dog with them. And they contacted us, firstly, to make a complaint about their situation, which we referred through to the dispute resolution team. But they also wanted to know if the Commission had something they could show people in those situations to provide information about the rights of people with assistance dogs. So, the dispute resolution team handled their substantive complaint, but our frontline team was able to communicate with all the different providers in New Zealand who certify assistance dogs, and together we created some brief guidance and a small resource that people can either print out themselves and carry around with them, or they can show the website. It's all published on the website now. So that's kind of shows the approach we take to complaints. Yes, we can offer a dispute resolution process, but when helpful, we can do other stuff as well to help address a broader issue. So that's one example. And by providing information to people who contacted us, we want to help empower people to resolve things themselves. We don't want to be the always swooping in to try and fix problems. We just want to help equip people with the tools they need to do that themselves. So another story is that someone who went to a gym regularly contacted us because there was a clause in their contract that they thought was discriminatory. It didn't affect them directly, but they were just concerned about it generally. And so we couldn't offer them dispute resolution because, as I explained at the beginning, you have to have suffered some kind of harm or disadvantage in order to qualify under the Human Rights Act. But that doesn't mean it wasn't an issue that we were interested in. So we were able to provide them all the information about unlawful discrimination under the Human Rights Act, and they went away themselves and talked to the gym with that information, and the gym changed the contract to ensure that that clause was no longer discriminatory against others. So that's another way that we can help. And just the third story, just around that kind of hate speech, harmful speech area I flagged earlier, is that someone complained they'd been on a bus and heard the bus driver making racist comments comments that they found racist against other customers. So they weren't personally impacted by that language, but they were concerned about it. And so they contacted us, and we love that. And so we were able to facilitate a conversation between them, the bus company, and the driver, in which they could have a conversation about it safely, explain the impacts. The driver could apologise to that bystander, and the company agreed to conduct training for all of its staff just to reinforce their code of conduct. So those are some practical examples of how we can help with stuff that people contact us about. Moving on to our dispute resolution process. So dispute resolution is all about helping people talk to each other. That might sound obvious, but a lot of people come to us expecting us to investigate complaints and make findings or recommendations. We don't do that. We are 100% dispute resolution. So in some cases, we'll do mediations with people in the same room together or online, but in the same meeting. Other times, there might be no direct contact between the people involved at all. It would just be the mediator going back and forth between the different parties and helping them communicate to resolve the complaint. It can look like lots of different things. It's not a strict process, it's flexible and adaptive to the needs of the people who are involved. But very importantly, it's confidential. So when you make a complaint to us, we won't ever publish details about that, and we expect the people involved to do the same. We want people to keep the process confidential so that they can feel safe to really take part in it and say what needs to be said to resolve a complaint. It's voluntary, which means we can't force anyone to take part in it. So if you were to make a complaint to us and we were to reach out to that other party that the complaint is about and they were to decline, we can't force them to take part. We just have to stop at that point. But we'll do everything we can to encourage people to take part. But at the end of the day, dispute resolution only works if everyone wants to be there. And lastly, it's very important that our process is fair to everybody involved. So the mediator doesn't take sides, doesn't advocate for anyone in particular. we can advocate for the Human Rights Act, but we're not advocating for individuals. So we're just running a process that helps everyone feel safe and welcomed and like they can take part. Yeah. So that's broadly how it works. And just got a couple of examples here. One, during COVID, we got a lot of complaints about people who had been declined from various places because they weren't wearing a mask. And so we did a lot of those complaints around mask exemptions. So one person, I've just picked one of those out. A patient complained that they were refused entry to a medical appointment because they weren't wearing a mask, even though they had a disability that prevented them from wearing a mask and had a mask exemption. So in that instance, and many like it, the mediator facilitated indirect communication between the parties. So there wasn't a mediation meeting as such, but the mediator talked to everyone involved, and just by going back and forth helped them reach an agreement where the facility could acknowledge that they'd made a mistake and apologise to the patient, and they made changes to their policies and processes so that people with mask exemptions could still access their medical help, whilst other vulnerable people who also maybe wanted to come into that facility, that risk was managed as well. So dispute resolution is really, it's quite a practical process. It's kind of helping the people hash out an individual resolution for their complaint, but it does sometimes have broader systemic outcomes that will help other people as well. So it's really worthwhile making a complaint, because the potential is it doesn't just help your particular issue, but it's got the potential to really help a lot of other people who might be in a similar position. Just in the interest of time, I might just leave the stories there, move on to the next slide. We can come back if we've got more time. So as I said, we can't, if someone declines to take part or if a complaint isn't resolved through our process, that's kind of where the Commission's involvement ends, and we close the complaint. We can't say, well, you didn't decide on an outcome, but we will. We don't do that. So we just close the complaint, and then people have got the option of taking that complaint to the Human Rights Review Tribunal if they want a legal finding. And to get support with that, you can apply to the Office of Human Rights Proceedings. So that is a separate and independent part of the Human Rights Commission, which I acknowledge is a bit confusing. We are separate organisations under the same umbrella, effectively, and they are completely independent from our dispute resolution process. But people can apply to them, basically for them to be your lawyers for the complaint, and they can represent people at the Human Rights Review Tribunal, or in many cases, negotiate a settlement before it even gets anywhere near a hearing. And so they get a lot of applications, and they can only accept, you know, a small proportion of those. But if you are thinking of taking a complaint to the Human Rights Review Tribunal, it's a free service. You can apply to them, and even if they can't help with your specific complaint, they'll provide a really helpful legal opinion about your complaint, which is in and of itself just a really useful service. So if you think you have experienced discrimination, you might have witnessed it, you think your friend might be going through it and you just want more information, or you've just got questions, please get in touch with us. You can contact us through our website, by email, infoline@hrc.co.nz. We've got an 0800 number. We've got other accessible ways. We've got a text. If you prefer text, there is a text number on our website that you can use. We even accept faxes, if you'd believe that. Yeah, there's a variety of ways you can get in touch with us, all listed on our website and a couple here. And we get a lot of inquiries and complaints. We get about 5,000 a year. But we get back to every single one. So not always instantly, but we always get back to people. So please don't hesitate to get in touch with us. We really want to hear from everyone who's got concerns about discrimination. or any of the issues we've covered here. Anything to add, Esther?
Nope, I'll just say the email again. That's infoline@hrc.co.nz, and our 0800 number is 0800 496 877. And we'll just stop sharing our screen so you can see everyone's lovely faces a little bit better.
Well, thank you so much, Anna and Esther. That's very, very helpful. And now we're going to open for the audience. So if you have any questions that you want to ask to Anna and Esther, you can either raise your hand by clicking on the raise hand icon, or you can put in the chat. Yeah, so if you do, feel free, but I do have a question myself. That's okay. So I have a lot of questions, actually. I'm all the time reaching out to the Human Rights Commission to get, clarification and advice. So in terms of employment, like we see a few cases where people, they have a sudden vision loss, and then maybe they're no longer able to fulfill all the tasks that were in their job, description. Is that it's fair to have like a reasonable accommodation if there's only like one or two tasks that the person can no longer perform, but they can do all the other rest? So how would you see the situation?
Yeah, well, bringing it back to the definition of unlawful discrimination, if that person was to contact us, we'd be like, are they being treated differently or unfairly because of a ground under the Act? Sounds like disability would apply in that case. Is there an area of public life? Employment is an area of public life, great. And are they being disadvantaged? Sounds like their job might be at risk. So yes, check. So we wouldn't say to them, you are being discriminated against. We would say, we can offer a dispute resolution process for this. We can't give you a legal advice or any advice really about whether this is discrimination, but we can definitely offer a dispute resolution and help you and your employer talk about that and see if you can come to a resolution. But yeah, again, as Esther said, reasonable accommodation. Under those circumstances, are there things that the employer could do to help keep that employee in their job? If there are and they seem reasonable, it's likely that they're obliged to do them. But we wouldn't make that call. But we get lots of complaints, not that exact one, but of that nature, and we provide dispute resolution, and lots of them are resolved. So we would encourage people to get in touch with that kind of complaint.
Okay, that's great. Oh, thank you so much. If anyone has a question, otherwise I have another one as well. I don't want to dominate the question, so just please feel free to put in the. Oh, we have a hand up. Yeah, David?
Yeah, I have a question. What's the sort of typical time frame for resolution of a complaint? Is it sort of like, could you expect it to take weeks or months or years, decades? What's usually involved?
Definitely not years and decades. I would really hope.
There isn't an exception to that, but yeah. I suppose
really.
Well, no, just the exception would be that if the I suppose not within the complaint service of the Human Rights Commission, but that if people don't reach a resolution and approach and want to go to the Human Rights Review Tribunal and have to make an application to the Office of Human Rights Proceedings, that can take quite a lot longer because they receive many applications. They're a very small office, and any kind of legal case where they need to prepare a lot of, they need to do a lot of preparation for a legal case that would go before the tribunal will take a long time. And there's also you can't go to the tribunal very quickly. So the tribunal has to, accept the case and for it to be on its roster. So when it goes outside of the complaints processes of the dispute resolution processes of the Human Rights Commission, then it can be quite a lot longer. So there are people who have spent many years working towards a human rights review tribunal case.
Yeah, we can't control them. It can be the tribunal can be very slow, but we'll do our best to resolve it ahead of that. And that really depends on the people involved and their willingness to resolve it too, of course. But once a complaint is with a mediator, I think a reasonable expectation would be months. It mostly depends on the people involved and how quickly they can come together, if it's going to be a mediation. Because sometimes, two parties might be ready, but the third one has got a really busy few months ahead, so it needs to be pushed out a bit. So really, it's hard to say exactly, but I would say generally within a couple of months, it should be able to, whatever dispute resolution process is going to happen, whether that's a mediation meeting or a more indirect process, it shouldn't last much longer than that. If it involves a government agency, and many do, they can be a bit slower to respond just because, there's layers of bureaucracy to get through there. But it really just depends. With smaller businesses or smaller employers and individuals who might be involved, it could happen in a week, there's nothing to stop that. It's just really about the individual circumstances of the complaint.
Thank you so much, Anna and Esther. I know that Alicia has her hand up. David, would you be able to unmute her so she can pose a question as well?
Hi, it's kind of more of a statement, and thank you for your presentation. But when your presentation was being played, you couldn't actually see your sign language interpreter. So I don't know if there's many people on here that were looking for that facility, but you could only see one of your cameras, not the interpreter as well. So you might. I don't know.
Thank you for the feedback. We will figure out with the tech what happened.
Yeah, maybe anyway, that's all. Sorry.
Thank you. If anyone in the audience has any other question, otherwise I do have another one, but yeah, this is an opportunity that you have to. Okay, so we have a question in the Q&A. Can you place that for me, Isabel? Can you read out loud the question, please?
Yes, Angelo asks, there are many organizations that use restructures to get rid of people with disabilities, and that have developed while they're employed by them, either through injury or illness. How can this be addressed?
Yeah, it's a really complicated. That's a really challenging question. I suppose one thing to consider is employment lawyers. Neither Anna nor myself are lawyers, and I wonder if that is an issue that could be raised through an employment lawyer. But I think, I would say, just even from everything that Anna said, there could still be opportunities to have conversations with an employer around a mediation if that is a concern. And remember, in any restructure, there has to be a fair and reasonable time for people who are affected to respond to that proposal.
Yeah, well, people with employment complaints have always got two options. Like if it's discrimination based, we're an option, obviously. And Employment New Zealand have the employment mediation service. So we both provide a pretty similar service in terms of it's mediation based, dispute resolution based. So in that case, someone could choose to go through either process. You can go either or, but there's no point in doing both at once, really. So it's best to just pick your favorite and run with that. But we do get complaints of that nature coming through our process. If someone believes that they have been made redundant because of their disability, that's something you can make a complaint about. With all complaints, there needs to be some kind of indication that that's not evidence or proof or things like that, but like something a little bit more than, I think this is why this happened. Something that indicates, that I think there's a reason, there's a link between what they're doing and my disability. And sometimes the timing of it might be enough, like, I developed this disability and then 3 months later, suddenly I'm being made redundant. That would be enough for us to offer a process. Just, I guess the reason I say this is sometimes people will contact us because they think they haven't got a job, and they may be right. They think they haven't got a job because of a particular ground. But there's nothing that actually indicates that that was the case, and it's quite tricky to move forward with those complaints. So in most cases, we need some kind of indication that that's to support what you believe has happened. But I don't want to put you off based on that. So in this situation you're talking about, you could make a complaint to the Human Rights Commission, or you could make a complaint to Employment New Zealand. The key difference being we can only work under the Human Rights Act. They work under the Human Rights Act too, and also all the other employment law. So they can do like unjustified dismissals and anything you can make a personal grievance about, Employment New Zealand can help with. So they just got a broader jurisdiction than us, but a reasonably comparable process. Yeah. So if you were to contact us with that scenario, we would provide you this information I'm giving you right here. These are your options. We can talk to you about them. We'd probably suggest you also talk to Employment New Zealand about them before you decided, and then we'd just kind of help you make the choice that's best for you.
Thank you so much, Anna. I know we are a little bit over time, but I just want to put another question. Well, first ask if anyone else has another question. Otherwise, I'll put one last question and then we need to wrap up. We recently got a complaint here about, and we're assisting a client with navigating MSCD forms not accessible in the website. So is that a complaint that could go to the Human Rights Commission, and what the Commission could do to assist with that?
Yeah, so let's think about it. Whenever we get a complaint, this is what we do. You're kind of getting a look in. Is there a ground not accessible because of, it depends, is it not accessible because of their disability, because of their ethnicity or where they come from, language related? Yeah, so that's kind of thing we'd be thinking, like, okay, disability, check. Is there an area, government services, check. Is it causing them harm or detriment, disadvantage, or they can't access the service? So check. So yes, we'd look at that and we're like, okay, it looks like we can offer a process here. So then we would talk to the person about what they're seeking. They just want to be able to access the website or whatever it is, or the process, the service. And then a likely process, I don't want to say for sure, because but a likely process that would be, we'd write a letter to MSD inviting them to take part in a dispute resolution process. And it's up to them if they accept or decline, but if they accepted, then, well, sometimes just sending that letter is enough for them to trigger their own internal review or some kind of action. Otherwise, we might bring the people together in a mediation. If the individual contacting us really didn't want to take part in a mediation, we'd see if there's something indirect we could do, maybe like passing communication back and forth. Those are the kind of approaches we'd be taking.
I suppose the only other thing I'd say is that with a systemic advocacy, strategic advocacy kind of hat on, the team, the disability rights team, would probably say, hey, that's something that affects not just an individual or a few people, but that's going to affect a lot of people. And that would be the kind of area that we would work in under strategic advocacy, where we would say, hey, government, and definitely in terms of Ministry of Social Development, we know you've signed up to the Accessibility Charter, you know, you're providing services to a lot of the people you provide welfare assistance to are disabled people. What's going on with your applications not being accessible? So there might be an area, and sometimes the complaints team will come and talk to the disability rights team around something that's going on in a complaint. We don't have direct input into the complaint itself, though we might provide information about here are some services that you can go to, here are some people you might want to contact. But that will feed into the kinds of strategic advocacy that our team does.
Which is a good point, because the kind of complaints we do share with the other teams, not the names or details or anything, but the types of things we're hearing about through our complaint function, and that does really help inform their work as well. So it's always great to get in touch with us.
Yeah, absolutely. Well, thank you so much. Just can you tell again, if people decide to reach out or have any questions that they were shy to make here, what is the email that they can reach out to pose a question? And
the best email would be infoline@hrc.co.nz.
Cool. Well, thank you so much. I will now invite David to do the closing karakia.
Kia karakia tātou. Kukua te wairua kia rere ki ngā taumata. Hai a rahi I a tātou mahi. Me ta tātou whai I ngā tikanga a rātou mā. Kia mau, kia ita, kia kore ai e ngaro. Kia pupuri, kia whakamaua, kia tina, huie, tā iki e.
Yeah.
Allow one spirit to exercise its potential, to guide us in our work as well as in our pursuit of our ancestral traditions. Take hold and preserve it. Ensure it is never lost. Hold fast, secure it. Draw together, affirm.
Thank you.
Thank you, everyone.
Thanks for having us.